apologies for being late. Any other? Any other going once? No? Okay. I want to welcome all of you. We've had a long delay, or should I say hiatus, between the last meeting and this one, so hopefully we can make some progress today on the issues. Part of the delay was for some meetings and discussions to take place outside of this chamber with the relevant parties looking at some of the clauses to try and get some clarity and hopefully some agreement. So I'm hoping that we would have achieved some of that. Other parts, other areas of delay would have been the use of the chamber, some breaks that we had, but we can hopefully push forward now. That will be my welcome and opening remarks. So I want to move now to the reading and confirmation of minutes of March 16, 2022. The minutes should have been circulated. So let me begin. Page 1 of 13. Pages 2 of 13. Three, 4, 5, 6, 7, 8, 9, 10, 11, 12, and the final page, page 13, 13 of 13. Are there any corrections? No? Can I ask for a confirmation of the minutes of March 16?
Chairman, I so move.
Moved by Member Gale, seconded by... Okay, seconded by Member Malahu Fort. Thank you very much. Matters arising. Are there any issues you want to raise that will not be raised, where we will pick up, which is on Clause 8? If I see no hand up, no expression of a matter arising. Okay, so we move on to new business, which is a continuation of the clause-by-clause analysis of the bill and outstanding examination of outstanding matters. So the last time we met, we were on revised Clause 8. You should have, would everybody have the sheet in terms of what has been done to date? It was circulated. So you should have a summary sheet of the decisions made by the committee on all the clauses. And it was printed. Okay. So if you don't have a copy, we can arrange for you to get one, but it was circulated. And so I refer to that for ease of reference and to follow. To page 4, revised Clause 8, limited interactions with the tobacco industry by a public body or public official. And I believe some conversation had started there. I'm going to hand now to Mr. Edwards so that he can just take us through.
Chair.
Yes.
Just a housekeeping matter.
Sure.
Could I request that in future, that instead of the morning of the meeting, we get in a copy of this, that efforts they made to send it to the members before?
It's a fair request. But when was that email sent? Oh, yeah, well, you're absolutely right. We need to try and do that a few days or so before, or at least a day before. Thank you for that, member, and point taken. All right, so Mr. Edwards, you want to just start us off with lead us on this?
Thank you, Chair. Thank you, Chair. And I must take responsibility also for the late circulation of the document. But it was intended really to track decisions that were taken by the committee up to the last meeting of the 16th of March. And also it has taken account of, what I'm referring to is the document that was circulated, which is the suggested amendments, which is not raising new matters, but is really intended to reflect decisions made by the committee and also take account of discussions that were usefully had between the Ministry of Health and the legal departments, Attorney General's chambers leading. So in relation to clause 8, and I'm going to refer to the document with the revised annotated text of decisions. Let me just go through step by step. So in relation to clause 8, the first point to note is that this clause is now limited in its application to specified public body or specified public official, being a body or official whose functions relate to the developing and implementing of public health policy with respect to tobacco control. So this provision is now not generally applicable to public officials, but only to those who are involved in the developing and implementing of public health policy with respect to tobacco control. We have also removed the reference to enforcement, so it is to avoid any overlap between general law enforcement functions. So this is focused on persons who are involved in public health policy with respect to tobacco control. Those are the officials to whom the provision now applies. The other clarification was in relation to the authority to whom communication should be made in relation to the actions or the interaction carried out. We will note that the proposed subsection 3 speaks to the appropriate authority within the specified public body that the specified public official is employed or engaged within. There was concern that the language had been too broad and that it was necessary to be very clear that we are speaking to the entity to which the official is attached. So this is the language that is being put to the committee to tighten up the linkage there. The other changes really are to ensure that the provision is specific in its application only to specified public officials or a specified public body. And in relation to subsection 6, the language again is tightened so that when we speak of enforcement, we're not speaking of enforcement in the broadest sense, but in the context of the provisions of the bill, where the authorized officers, which is a defined category of persons, have specified functions under section 28, under clause 28 of the bill, and we have sought to link in subsection 6 the reference to enforcement functions to enforcement functions of authorized officers as opposed to enforcement in the broader sense. Subsection 7 has been removed. There was concern about the reference to offers of hospitality, and the ministry, after further consideration, proposed that in the interest of clarity, it was clarity and completeness. It was not necessary to have that subsection 7 in that provision. There is sufficient alternative provision that would address that issue of hospitality.
Where, Mr. Edwards, where would that, sorry Chair, where would that come under? Because based on the note here that it will review at the next meeting, which will be now, can you point us to that section?
Well, we have the language in subsection 8 as well as clause 9 we consider to be both broad enough to cover any issue of accepting offers of hospitality. And in fact, subsection 8 makes specific reference to hospitality, 8C. So, Chair, that summarizes the proposals in relation to clause 8.
The issue of specified public officials, which means persons who are directly involved in the in the laws,
implementing and developing
of the laws, is quite clear. But implicit in that, it means that other public officials could be engaged in the promotion of the tobacco industry. Because if you're going to specify the ones who are going to be regulated, the ones that are not specified have a free hand to do what they wish.
Not really, Chair, because remember...
I want to make that clear because, yes. You know, that would be a concern to me. And I'd like to ask what are the sort of precedent that may exist in other jurisdictions and how it deals with public officials.
This is actually...
You don't want a government to have some members advocating for the most dangerous product known to man in its consumption, and another that is regulated because they deal specifically with the particular industry. That sends very mixed signals, I think.
Yes, in fact, Chair, it is significant what you have raised, because in relation to the specified public official, that is consistent with the formulations in the region, in the Caribbean region, of similar legislation, where the focus is really on the persons who are directly involved in the development of the public health policy. Now, clause 9 is the broader provision which deals with conflicts of interest, and that is not restricted. That is the provision that addresses, to some extent, the concern that you have, Chair, that all public officials will have a duty in relation to avoidance of any conflict of interest by activities that may involve the tobacco industry and themselves. So clause 9 is the one that is of broad application. Clause 8, which also attracts a disciplinary penalty, is the one that is focused on those who are particularly responsible in relation to tobacco control.
Okay, so take us to, if there is no other question on this clause, you want to take us to clause 9, then let us see if it captures the kind of holistic approach that I would...
And just to be sure, Chairman, because when you hear the term conflict of interest, and the first indication of a conflict of interest must always be a declaration of such. And when you use a wide rubric now of public officials, I'm going to ask you, Mr. Edwards, where it is, just to give us a clear understanding what this conflict of interest would entail as it relates to public officials. I am very clear in terms of what is being indicated for the specified officials. That's very clear in my mind. But we ought not to leave any gray areas where those that are not defined as specified, but are called public officials, their scope of permissiveness. So I would just want you to somewhat bring some more clarity in terms of the role of the conflict of interest in that regard.
All right. To you, Chair, in response to Senator, in Clause 9 speaks specifically to the matter of disclosure, the obligation to disclose. So the proposed language is obliging a public official who has an interest, whether of a pecuniary or business nature, in the tobacco industry to disclose the nature of the interest. So it's first and foremost an obligation to disclose, and then the indication is when should that disclosure take place. On a commencement of employment or engagement of the public official with the public body, or as soon as the public official becomes aware that they hold such an interest, that is when the duty to disclose arises. And then subsection 2 provides that the public body shall record the disclosure made to it. And then the obligation on the public officer who has made such a disclosure is, 1, not to be present during any interactions of the body. Remember, they have already disclosed that they have an interest in the industry. So they should not be present during any interactions of the public body that they're connected with, interactions with the industry. They're not to take part in any decision-making of the public body relating to the industry. They shouldn't be present in any deliberations of any public body for the making of that determination. They should not influence, directly or indirectly, any other person involved in the decision-making of the public body. So it's very specific to persons who have some interest of a monetary, financial, or business nature in the tobacco industry, that their actions or interactions would be restricted. Then subsection 4 speaks to persons who are seeking employment as a public official in a role that involves the development or implementing of policy. So this is not just a general employment in the public service. These are persons whose role may eventually involve public health policy relating to tobacco control. They are to declare any current or previous activity, occupational activity, or affiliation with the tobacco industry, whether gainful or not, meaning it doesn't have to be something of a financial reward nature. It could be just that they're on a board or a committee connected with the industry. They're to disclose this for the purpose of determining whether a conflict of interest exists or is likely to exist in relation to that person. So this is somebody who is seeking employment in some public position.
Let me ask for some clarity on that. Is it that in this case, if you're seeking employment, the role to which you're seeking employment would have direct influence or conflict? Because you can be seeking employment in an organization that may not have any conflict in the future. So this employment is specifically for roles that may have direct influence or conflict.
Exactly. It could be, for instance, a policy analyst in the Ministry of Health and Wellness.
Right.
Yes.
Okay.
And then subsection 5 provides that a public official who has a role in the developing or implementing of public health policy with respect to tobacco control shall declare any interest in the tobacco industry to the appropriate authority. We get back to that term, appropriate authority, and that is meant to refer to the person in the body to which they're engaged or employed who has authority over them. That's really the appropriate authority. and make a divestment of that interest in such manner as may be prescribed. So this is going beyond just an obligation to declare, but it is recognizing that the law may make provision for a divestment process in these cases. And we're speaking of persons who have a role in public health policy. Subsection 6 speaks to an entity which is part of the tobacco industry. Now, this is putting the obligation on the other side. Any entity which is part of the tobacco industry shall not grant any monetary or non-monetary payment, gift, contribution, or service to a public body or a public official. And then on the other hand, a public body or public official shall not receive any monetary or non-monetary payment, gift, contribution, or service from the tobacco industry. Subsection 8 prohibits a public body from granting any incentive, privilege, benefit, or any other preferential treatment, these words are bracketed, to the tobacco industry to establish or run its business, or preferential tax exemption, again bracketed, in relation to manufacturing or advertising and promotion of tobacco products or relevant products to a person in the tobacco industry.
Sure, Chair, can you remind me why is it bracketed?
These are bracketed because there are decisions to be made. There are proposals, and we invite the committee to deliberate and decide whether they would wish the language to remain as it is.
Excuse me, Chairman, I had raised this issue when we had a meeting with the Ministry of Health. The words in the brackets, in the second brackets that talk about preferential tax exemption really do not have a place in this bill. Tax exemptions are dealt with under discrete tax laws, and with the fiscal framework that we have now, I don't think the Ministry of Finance and our international partners would want to see these types of waivers creep outside of the specific tax legislation that we have. We used to, and we removed all of them before. So we no longer have specific laws that deal with the tax exemptions. Those are dealt with in the specific tax laws.
Chair.
Go ahead.
And I was going to say that the ministry does not have any objection at all to removing that language.
What's the precedent around laws of this kind? Anybody?
But while the consultant is answering, Minister, Ms. Aldridge, wouldn't the Ministry of Finance be considered a public body?
Sorry. So you're looking at the opening words that the public body shall not grant any incentive and that the Ministry of Finance wouldn't be able to. That is one way of interpreting the provision. But just to go back to the chairman's query, the regime we have in Jamaica is that when it comes on to tax exemptions, that's under the sole purview of the Ministry of Finance and the Public Service. So although you may have precedents in other jurisdictions, we have a specific regime here that we would have to take account of.
I need to be guided on this because while I respect the originality of our regime, I know that laws are normally based on referencing precedent in other jurisdictions, and I believe these laws that we're dealing with and all others tend to have that kind of base. So I wouldn't accept that somehow we are entirely original. Mr. Edwards, you can comment.
It's the source.
You can comment on it, but worst case scenario is that I'd like to see what the precedent is, because one of the things that I think we need to accept around these laws related to tobacco is that they are again, maybe contradicting myself based on what I said earlier, they are almost exceptional. Wherever you review tobacco legislation, they are based not just on a charter that countries agree on, sign on to, including Jamaica, but they tend to recognize the deleterious effect of this particular activity and promulgate rules around the choice that one makes to consume, in full recognition that ultimately leads to their demise. And governments, therefore, tend to be a lot more rigid, if you will, in terms of how those choices are made. So I'd like to be guided. Mr. Edwards?
Yeah, Chair, it is reflecting the international guidelines that we have been looking at in relation to tobacco control. So, for instance, the WHO guidelines speak to these types of issues in relation to conflict of interest and the challenges between public bodies and the tobacco industry. Preferential tax regimes is one of the issues that the WHO has raised. So this is the kind of background that informs us putting forward this type of language.
To the extent that some people have a problem with the WHO, as oftentimes is the case, except for those of us who are in the health space, can you cite countries that are of this particular view, or a list of countries that would support what we're saying, or not?
I can.
If you need some time,
I just need to get the list, yes.
We can come back to it. So let's leave this for now. And that would be the last. No, this is.
Sorry, Chair, can I just ask what was the committee's decision on clauses 8, 9, and 810?
Right, so I was actually going to
And also on same clause 9, the decision on the offense creating provision, 910.
These are clauses that we just went through?
Well, you stopped at 9.8. And I'm asking
9.8,
about,
right. Can I,
9.10.
sorry, I should have actually asked for an acceptance having gone through 8. Mr. Edwards, with your revision, I kind of allowed you to move on to 9 because I'd queried the all-encompassing framework. So can we accept that that 8, based on what has been proposed, is fine? So we can move on to 9?
Sorry.
I didn't see any objection.
Oh.
Yes.
So, sorry, Chair. So the committee members have gone through clause 8.9 that tries, it's an implied amendment to the public service regulations. That's in 8.9. And 8.10 that talks about disciplinary proceedings.
We did go through 8, we went through 8 in its entirety. What is your concern based on what is before you?
That this is impliedly amending the public service regulations.
Mr. Edwards? So we're back at clause 8 then. Can we finish it? I think it's best to just, it's for tidier proceedings.
Chair, could I ask the SG, you are referring to 8.9?
Yes, 8.9A, speaking about proceedings under the public service regulations. I'm not sure which proceedings they would be talking about. And if you're just talking about the regular public service regulations, you don't need to put it in this law. Those regulations would apply to the officers to whom they are to be applied. So under the public service regulations, it gives you a regime. It applies to civil servants. It always applies. So you don't need to put it in another law because it already applies to civil servants. If you're trying to have it apply to other persons, this is not the way to do it. You can't apply, I would suggest that this is not the way to do it if you want to apply it to persons who are not civil servants. So these were comments I'd made before.
Yes, I recall.
And I just wanted to know if the committee, having heard those comments, still wanted to retain this provision in this way. Further, in 9B, the way how public official is defined, I think it still refers to a parliamentarian. What disciplinary proceedings are we talking about for a parliamentarian? I'm just saying, you know, you define the words, it applies to a whole set of people, and then you put a provision like this. I don't know how it would apply.
But 9B has specified public official, which wouldn't, based on our acceptance of that particular term, definition.
Sorry, so that has been agreed, that it's a specified public official with the new, I don't know who that is.
Say Edwards.
So, subsection 9, the question would be, in the absence of this provision, because we always ask the mischief, in the absence of this provision, if this section 8, clause 8, as proposed, would automatically apply to public officers, the Ministry of Health will be fine with excising this provision. But the concern is whether, in the absence of a provision like 9, maybe not exactly as worded, but a provision like 9, whether the breach of any of the requirements of clause 8 would automatically constitute grounds for disciplinary proceedings. That is a difficulty that the ministry had, that it wouldn't automatically constitute a ground for disciplinary proceeding because it was an omission of the requirements under clause 8. So that is the reason why we have subsection 9. But if it is, I think SG is saying that in the absence of 9, a breach of any of these provisions between subsection 1 to 8 would automatically constitute a ground for disciplinary proceedings. I just need to be clear.
Chair, what I'm saying is that if the Ministry of Health and Wellness wants to expand the grounds of disciplinary proceedings under the public service regulations, then discussion should be had with the Ministry of Finance and the Office of the Services Commission, as they are currently doing a review of the public service regulations. That's the way to go about it. We have not expanded the public service regulations in this manner. Remember that the public service regulations are actually a creature under the Constitution. So they're not made under an ordinary law. In fact, they weren't even really made under the Constitution. They are pre-Constitution. They are 1961 regulations, and our Constitution is 1962. I'm suggesting that this is not the way to go about it.
Have there been any discussions with the Ministry of Finance on this particular issue?
Not on this issue, Chair, no.
Okay.
Chairman?
Yes.
If a discussion is to be had, it would have to be had by your ministry, certainly by yourself as minister, or at the level of your permanent secretary with the Ministry of Finance. But the Learned Solicitor General is correct that you don't seek to introduce provisions that would intrude on the public service regulations in this way. If the matters that are set out are believed to be important, then I would just endorse the suggestion that a conversation be had with the Ministry of Finance around this matter. And my ministry can be of assistance in the process. But I would ask that the caution be heeded and that the provisions of the public service regulations not be impliedly amended in the way that the provisions in the bill is seeking to do.
Okay, thank you, Member Malahufort. I recognize Member Daly. Member Daly, you have your hand up? Or no? Well, her hand is up. Okay. I take the point from the Minister of Constitutional Affairs supporting the SG's position. So what I would recommend then is that we asterisk that particular section and that some conversations be held with the support of the Minister of Constitutional Affairs with the relevant ministry, and let us try and get that back for discussion later, a decision around that. Yes.
So, Chairman, let me try and understand the objective as laid out. In Clause 8, it speaks to the scope of permissiveness for the specified public officials. And then, what you're seeking to do into Clause 9 is to outline how disciplinary proceedings could take place. But what you have sought to do is to import now the public service regulations to be utilized as the organ to treat with the disciplinary procedures. Is that the objective?
The public service regulations is one of those stated, because we speak of the public service regulations insofar as they apply to public servants, but public official is a broader term. So that's why we say public service regulations 1961 or other applicable disciplinary provisions. But yes, the intention was to seek to incorporate these breaches as disciplinary matters under the public service regulations. And we, the ministry is very willing to engage appropriately to arrive at a proper, a more acceptable approach to achieving that end.
You see, the public service regulation is specific to a group of civil servants. And in this case, what is contained in it may very well be persons employed that are not specifically civil servants, but employed to public bodies. And in instances, you may have these public bodies establishing their own rules or their own disciplinary type procedures. So the conversation really needs to take place as to what better way we can find to connect the objectives to which you're seeking.
So just to yes, go ahead, member.
Right. So the point made by Member Kavan Gale brings another dimension to the discussion. The regulations would apply strictly to the category of public servants known as civil servants. It is, you can also seek to use the standards that are set out in the regulations, in the public service regulations that narrowly would apply to civil servants. You could use those same set of provisions to apply to the wider public servants who would not, strictly speaking, fall in the definition of civil servants, but it's going to be how you do it. So if the aim is to have perhaps a standard disciplinary procedure to persons, applicable to persons who are not only civil servants, but who are wider public servants, and you want to use the civil service standard, I think that can be done, but it's how you do it that would determine the propriety.
Right.
Yes.
So, which is why I agree that a conversation needs to be had at that level, because my understanding is that you are incorporating an existing body of legislation to support the breaches, right? But then you have to, it represents a subset of those persons that you're speaking of who would fall under that legislation. Am I correct in that, Mr. Edwards? So the question is, what would you do with the others who fall outside of that? And the question is whether or not there's a way to do it. Maybe this Solicitor General could advise on what may be a better way, maintaining the need to recognize breaches and to deal with those breaches, because that is the injury we're trying to correct. So whether it is you cite another rule or law, a combination of laws that exist, I would like to challenge her capacities and her office to assist us in identifying so that we do not water down what we're trying to achieve while still keeping in the boundaries of the laws. Is that something you could help us with, Madam SG?
We can try, Chairman.
I appreciate the effort. So, Mr. Edwards, you're going to need to have a conversation, you and your team, to come up with something for the next meeting. Can you move on?
Chairman?
Yes.
May I just suggest, I know you have been concerned about the pace at which the review by this Joint Select Committee is taking place on a number of fronts. It's going to be very important that follow-up conversations take place between meetings, and especially when comments are raised which require clarity around the policy or for dialogue or discussion to take place with other ministries. It's going to be really important that those are done in as timely a manner as possible.
Thank you for that intervention. Your ministry included, Madam Member, the Constitutional Reform Ministry is absolutely critical to this. So one of the reasons why we have had these delays is because we have allowed time for these consultations to take place. I'm on record of saying that. But clearly when we get here, there seems to always be issues. So we're going to keep slugging away until we get to that point.
Sure.
But we crave your leadership on this also.
I think the real point is that any clarity in the public health policy is a clarity that the Ministry of Health itself will have to provide, taking into account questions asked or comments made from the consultations, particularly with the legal teams.
Thank you, Member. You had a point.
Yes, Chair. I hate to detain on this particular matter, but I crave your indulgence. And I am going to ask the SG to again look at 8.9. Because 8.9, a breach of any provisions of this section by a specified public official constitute grounds for disciplinary proceeding against a specified public official. We all agreed on that. 9A says, in the case of an officer, employee, or agent of a public body being proceedings under the Public Service Regulations, 1961, or other appropriate disciplinary provisions to which such officer, employee, or agent is subjected. And my late thinking of this particular section, Chairman, suggests to me that it covers the likelihood that you're going to be dealing with a civil servant, hence the Public Service Regulation, or other individuals from, as Member Gale said, from a public body, which might not be a civil servant, but have their own disciplinary proceedings. So does it really go in as opposed to what we want to have here, for want of a better word? Can it not continue? Because, I mean, there are options provided for in this.
The question is whether these options need to be cited specifically. I'm understanding that to be the concern, rather than to give an impression that one body of rules can apply to persons who are not captured under those rules. Is that the concern that you've raised, SG?
No, and I don't read the provision in the way Member Guy has read the provision. I read the provision to say exactly what it says, a literal interpretation, that if you breach the provisions of the section, so for instance, you accepted direct funding, it would be considered disciplinary proceedings under the public service regulations. That is not currently a disciplinary proceeding necessarily under the public service regulations. My concern is when you look at all the provisions, all the subclauses, you could likely be expanding the term what is considered disciplinary proceedings, whether under regulations 43 or 44 or so on of the public service regulations. That's the concern I have. And what I'm saying is those regulations, we have a lot of case law on them, and every year we have quite a bit of litigation going on about those public service regulations, primarily because there are inconsistencies with those regulations and the Constitution. And so I'm saying you're treading in very dangerous waters if you're now trying to impliedly amend those regulations and bring this and say that these proceedings under Clause 8 would now be disciplinary proceedings under the public service regulations. I think there may be a better way to deal with it instead of getting to that mire.
And I'm asking for that support to find that better way. But I get the point you're making. You've kind of expanded on my clarity even more by what you've just said, because you're now saying that the public services regulations would not qualify at all, or likely not qualify at all.
They may not for all of your provisions. They may not.
Huh?
They may not for all your provisions, because your provisions are very specific to tobacco.
So the question is, what else if not that? And I suspect that is where the challenge is. Are there other...
What the Solicitor General has done is brought further clarity to the objective to which we're seeking to achieve. So we have some clearly defined act of transgressions on the one hand, and we're seeking to utilize the public service regulation to suit these rules when they are not so aligned in the public service regulation. And that, as she has clearly indicated, we may very well be trying to amend the public service regulation, and we have no such authority to do so.
I'm not sure if we're trying to amend it, but the question is whether it's aligned. Mr. Edwards, are you appreciating what is being said, and do you have a counter to that, an explanation of it, or you prefer to have a conversation beyond today?
I am quite appreciating the Solicitor General's concern, and I'm seeing the primary concern, and maybe Solicitor General could clarify whether I'm interpreting it correctly. Primary concern being the implied amendment, not the amendment, quote unquote, but doing it in an implied manner. I see that as one of the significant concerns that the Solicitor General has. Is that so, Sergeant? Through Chair.
Can you repeat that, please?
No, that I'm interpreting one of your major concerns to be the fact that it's an implied approach as opposed to an express approach in terms of amending or purportedly amending the public service regulations. That is one of the major concerns that you have.
Yes, correct.
So what's the decision that you'll withdraw? You'll
yes,
ask
we will.
and then you have a conversation. All right. Is there any other of Clause 8? Any of the other subs of Clause 8 that is of concern?
810.
810. Mr. Edwards, take us through that, or maybe you should express what the concerns are.
Yes, just that you're creating an offense of aiding and abetting, but the primary offense is not there. there is no primary offense, so you can't be aiding and abetting an offense that doesn't exist. Because we had changed the scheme from criminal offense to disciplinary proceedings, but 810 still speaks of a criminal offense of aiding and abetting, but there is no criminal offense.
It had been deliberately worded this way because we didn't believe that because it wasn't speaking to aiding and abetting an offense, that couldn't be an offense. In other words, we're saying you're aiding and abetting a breach in a particular way, and by aiding and abetting, maybe it's because we're using the language of aiding and abetting, because our intent was really to criminalize somebody who is assisting in the breach of these provisions, whether these provisions themselves attract criminal liability or not. We're saying that the mere fact that you're assisting somebody to carry out a breach, even if that breach itself constitutes a disciplinary offense as opposed to a criminal offense, then you can be liable criminally, whether or not the activity that you're assisting is a criminal offense.
So I'm a little more confused. Hold on, 1 second, Mary.
Chairman?
Yes. Who is there? Oh, yes, member.
I just heard Mr. Edwards' explanation, but I believe it does not quite hold, because if the conduct that you're aiding and abetting is not criminal conduct, then why would you want to escalate the aiding and abetting to that? Clearly, it's wrong. And I mean, conduct being wrong can be wrong at different levels. But if you don't make the conduct being aided and abetted a crime, I think it's going to be very difficult to persuade or for it to be sound to have the aiding and abetting. It's just really wrong. So who it is that would be aiding and abetting? Is it anyone? If it is someone within the public sector who aids and abet, then that person too could be subject to disciplinary proceedings. How you deal with someone else outside of it, it's really the live question. But I don't know that I find the argument, the response of Mr. Edwards to be persuasive enough.
Chair, I respect the views of the Honourable Minister, but I've indicated the approach was to criminalize aiding and abetting, whether or not the action being abetted itself constituted an offence. I don't think there is, and I will not proceed any further, Chair.
I mean, this is an open forum. If you have an alternative view, I have no issues. I think it's important to make that alternative view. Is it that you need to? Is it that it's a matter of rewording?
No, Chair.
For clarity, or is it fundamentally a flawed statement?
The intent. Let me explain the intent here. The intent is that, and this applies to persons outside of the public service, who may facilitate the official breaching these provisions.
Mr. Edwards, it would be better if you give us a real-life example then, for example, while you're explaining it. I think it would help me personally. Are you saying that if someone from outside the civil servant gives money to somebody there, right, to do something which runs contrary to this, wouldn't that be covered under different legislation in terms of?
Not necessarily.
Okay.
Not necessarily.
So explain in that context for me
then. That is so.
Go ahead.
Good morning. The definition.
I'm not hearing you. You have to speak clearer, closer to
maybe this doesn't work. The definition.
Just go closer to the mic. It's on, but you're.
Oh, it's not. The definition of specified public official, as presently crafted, doesn't mean in the case of 10 that you're dealing with someone who is not a public officer. It doesn't. is only, what you just said a while ago, Albert, is that you're talking about people who are outside the public service.
No, I was using that as an
example.
example. I'm not saying it would not apply to other public officials.
Oh.
I was just saying that this is the area that would target persons who are not in the public service, who may be assisting in these breaches.
Well, if it's
but
intended
it could also
target,
be somebody in the public service. Yes.
Well, yeah, but if it's intended to target persons who are not in the public service, it would need to be
It's not intended to be limited. That's what I'm saying. It's not intended to be limited to persons outside. But all I was saying is that this is a provision where the offensive actions of persons outside of the public service would be dealt with. But it's not limited to only persons outside of the public service.
Sorry.
I see where...
I have two concerns in terms of the approach. In the first instance, you are treating with those inside the public body. And then the objective is moving towards disciplinary procedures. But then in the same scope, you are seeking an application to have those that are outside of the public body to be included in the same objective rubric. And then you are seeking to apply criminal proceedings towards those. I would want to suggest for clarity that the first approach must be to deal with those inside towards disciplinary procedures and apply the criminal application somewhere else and not in the same scheme that you're seeking to approach. I see what you're trying to do, but it's a question of going down the railroad track and jumping the track to treat with someone else.
Mr. Chairman, might I?
Yeah, go ahead.
I hope you hear me. I'm somewhat supporting what Senator Gale has just said, because based on what Mr. Edwards is suggesting, it's not an aid and abet offense that he wants to put into the law there, and it can't be, because as the Solicitor General quite rightly indicated, you cannot aid and abet. You can have an offense that aid and abets something that is not itself an offense. The principal offense must exist before you can have an aid and abetting offense. So this can't be that. It must be then that there is a substantive offense that Mr. Edward wants to put in relation to people outside of the public service. And that's, I think, where Senator Gale was trying to get to. Now, how you do that and what it should say and what is the action that you're trying to criminalize is another matter. But this is not the way you do it.
All right, tell you what, based on all the contribution of members, what I'm going to recommend is that we asterisk for further consultations 8, 9, and 10, and move on to clause 9. So Mr. Edwards and team would need to further consult on those two clauses. Can I get an agreement on that? Agreed? Yes, member
Are
Guy.
you saying clause 8, 9, and 10, or is the sub clause?
Clause 8, subclause 9 and 10.
Okay.
The two that have been the
Right.
issues of, differences. So, Mr. Edwards, just make a note of that and let us have a conversation around those two. If all are agreed, then we move on to clause 9, which we were discussing. Mr. Edwards, there was you were in mid-flight there when we returned to 8. Can you complete that for us so that we get the input from members?
Thank you, Chair. I believe we were looking at the issue of preferential tax in 8, so it would have been subsections 9 and 10 would have been remaining in clause 9, and subsection 9 speaks to the fact that the provisions of this section shall not limit the operation of any other provisions of law or disciplinary rules not inconsistent therewith to which a public official would otherwise be subject to. The idea there being that it is recognized that there would be other provisions of law or provisions under disciplinary schemes that relate to conflicts of interest and matters dealt with in this section. And the intention is not to limit the law or rules that would otherwise apply to the public official in that regard.
Okay, so on clause 9, subclause 8, the issues around taxation would require further clarity and agreement based on the issue raised by the SG. Are we agreed on that? So we would asterisk that and have a further consultation on that. Is it that we have accepted all the other subclauses? Yes, SG.
No. Recall I had raised a concern about 910, about criminalizing disclosure, a disclosure regime. When you have a conflict of interest issue, the regime is usually you declare it, you disclose it, you don't participate, and so on. But this goes further to criminalize the conduct. And I'm saying that is something that the committee should look very carefully on.
Okay, so you're concerned about the criminalization of this lack of disclosure. What I'd ask that you do for the next sitting is, Mr. Edwards and the team, cite where it exists any sort of precedent around that particular issue. I mean, is it that we're being overly draconian in our jurisdiction? Is it something that exists elsewhere as it relates to this particular issue, meaning tobacco?
Right, so as it relates to this issue, I recall that it is in like the Kenyan regime, but the Kenyan regime is different from ours because they have specific legislation that criminalizes all of this kind of conduct. So then you can understand why it was put in their tobacco legislation, because it relates to that other wider piece of legislation they have. We don't have that kind of regime here, which is why I take your point that you're asking the ministry to do some further work, but I'm saying there is an example, but I don't think it's a very useful example for us.
Okay, point taken. I am asking for an expanded list of examples, which could also possibly include the Caribbean region.
It does include the Caribbean.
So what, you have that now, or
yes,
you want to?
I mean, like we can speak of Guyana.
Okay, go ahead.
Countries like Guyana, specifically, I can quote. Can you read it?
Not hearing you.
In the Tobacco Control Act for...
You have to go closer to the mic, Katie, and I can't hear anything you're saying.
Katie Ann Birch, Acting Principal Director, Research and Policy Development, Ministry of Health. In the legislation, the Tobacco Control Act for Guyana, Part X deals with protection of tobacco control policies from the tobacco industry.
Still not hearing you. Use the other mic if that one not working. Or you need to go closer to the mic. Yes.
Okay. So Part X of the Tobacco Control Act for Guyana speaks of protection of tobacco control policies from the tobacco industry. And they have provisions related to duty of the government to prevent tobacco industry interference, interaction between government and the tobacco industry, prohibition on partnerships and endorsement from the tobacco industry, prohibition on voluntary contributions from the tobacco industry, conflict of interest in employment, that is section 44, and under section 44, which speaks to the conflict of interest, it speaks to the government shall require any person applying for or under consideration for employment, contract, or voluntary work related to tobacco control to disclose any related conflict of interest, which may include but not necessarily be limited to ownership of any stock holdings or other financial interest in the business in the tobacco industry, any occupational activity, whether or not for compensation with the tobacco industry, including serving as a member of the board of directors, any other conflict of interest as may be specified in regulations or government policy. And they go on to stipulate that any person who fails to disclose a conflict of interest under this section commits an offense and is liable on summary conviction to a fine of $200,000 and appropriate disciplinary action or contract termination in the case of a contractor, in addition to any other penalty that may apply.
You're citing Guyana. Are there any other that you know of in the region that is? Madam Solicitor General, can you identify any comparisons or differences with what is being promulgated here versus what you have been saying?
I don't know. I've never looked at the
that's fine. That's fair enough. Fair enough. So maybe what I'd like to look at is to see how extraordinary, based on what our rules are, we are in terms of this particular clause. So I'm prepared to hold on it and ask the team to do some background work, and then next time we come back with a conversation around it. So we determine either way, okay? Is that okay? All right, sure. Would that then take the...
I mean, we can look at another one rather than just the Guyana as an example.
Yeah, that's the point I'm making. That's the point I'm making. Okay. I want to be comfortable that we are not in betraying any sort of core work that we have, or the foundations of our own legislation, even though I do agree that in this case, I maintain there are extraordinary circumstances that justify discouraging tobacco consumption. So we'll do that. Would that then take us to clause 10?
I've said this before, but I think it needs reiteration at this point in time, now that we're looking at the other pieces of legislation or legislation from other jurisdiction. I raised this point much earlier in the deliberations at previous meetings as to how we ensure that we formulate laws which would not contravene Chapter 3 of the Constitution. And I understand your concern about giving laws that will create a better health for the country in terms of tobacco abuse and its use. But we also have to be mindful that they conform with the Constitution as it relates to Chapter 3. And I've asked the SG before if there's anything within what we're doing here. I think Mr. Edwards had replied that no, nothing is contravenes the Charter of Fundamental Rights and Freedom. So I think we still need to be mindful of that when we look at others.
Which is why we're going through this so painstakingly slow, remember? So we're at one. At the same time, I think it's important for us not to allow any sort of rules that can be worked with or around without breaching the fundamental constitutional construct to dilute what is a very important public health issue. And that's our responsibility, I think, as legislators. Perhaps we need to, at the beginning of these sessions, remind ourselves as to what we're trying to achieve and what the deleterious impact of tobacco consumption is, because it's important that we match the effect or impact with the extent of the legislation. Okay, so Mr. Edwards, you want to move on to 10? We have two sub-clauses, both in 8 and 9, that we have to come back to. We now have...
Sorry, I may have
actually
missed
11.
Which one in 9 that we need to come back to?
9
which one of the sub-clause?
Would be 9 and 10.
No, is there a
No,
sub-clause
sorry,
in
10,
9?
10.
Sub-clause
10 and 8. 8 and 10. Sub-clause
Right.
8 and 10.
Subclause 8,
And
I
10.
have it in my notes that we're coming back to we're coming back to clause 8, subclause 9 and 10.
Yes, and,
Right.
and clause 9,
And clause
subclause 8 and 10.
Oh, okay.
Okay?
Thank you, Chair.
All right, sure. All right, so let us know, Mr. Edwards, you want to continue on the summary sheet? I think we are at, I think, based on what is here, there's no amendment was recommended for clause 11, clause 12, prohibition of smoking in
Sorry, I'm sorry, Chair. As it relates to clause 10, though, the comments I made in relation to clause 910 apply to clause 10.2. Again, criminalizing a disclosure regime. I think whatever decision the committee takes
on the first, yes,
I think
we'll follow through. Understood. Understood. So you may want to just note that. Thank you. So would we then go directly to 12? 11? But 11 says here no amendment was recommended. So 12, if we're all agreed on that, then 12 would be the next substantive comment. Mr. Edwards?
Yes, the next provision, Chair, is in relation to 12. We're having redefined relevant product. No further amendment to clause 12 was needed. 10, the point is taken that the question of whether there should be an offense is linked to the determination of the earlier matter in relation to clause 9.
But isn't 10 a little different? 10 would be a person who is not a public official being told that they cannot engage in a particular kind of activity within a period of 3 years after ceasing to being a public official. And I think that that is the conduct that should be criminalized, not the first part. The latter part of 10, I don't think is...
Where are you? Sorry, I was distracted a while ago. You're at 12?
No, 10.
You've gone back
I'm
to 10.
sorry. I'm sorry, Chair.
Oh.
I was just saying that in relation to 10, where the 10.1b, I actually don't think 10.1a is necessary, because the conduct that is being targeted in 10 is actually engaging in a particular kind of activity within 3 years of having been involved in the policy development. That is the activity that is being targeted there, and that is the activity for which the offense should apply. I think in that case it's different. I don't think that you just need to tell this person that they cannot do it. I don't think they need to say they must inform the public body, and then having informed the public body, you're saying no, but you can't do it. So just go straight to say that you cannot do it.
So is it an issue?
And if you do it, that's an offense.
Is it an issue of disclosure, or is it an issue of
this is the point. It's not disclosure.
Okay.
It's engaging in a particular kind of conduct.
Okay.
It's non-compete after.
Yes.
Once you leave, you cannot
For 3
engage
years.
for 3 years.
Correct. That's what it's saying. And if you do, you have committed an offense. And I think that's all that 10 should be doing.
Any other comments on this? Madam SG, you normally have a comment, which we welcome. You have any comment in this case?
No, Chair.
Oh, okay. All right.
But
Mr. Edwards, that sounds logical, but the law is not always logical. Is it? I'm beginning to regret that I'm not a lawyer, but is it? What's your take on what is said?
Well, I can't disagree. I'm not disagreeing with the director, Ms. Wilkins, but it's just that A is dealing with a different aspect of things, because B is the straight non-compete, but A is speaking to an obligation to indicate an intention that you may have to engage in such activity. So it's a question of whether the committee wants to address this in the legislation or thinks that it's not a mischief. It's not a matter that should be addressed. But they're different. A and B are different.
What's the difference between... Are you saying that the two sub-clauses are unrelated?
No, they're not unrelated, but A is a disclosure obligation. And B is just a non-compete, saying you should not engage in any activity.
Why would you be required to disclose if you are required more strictly not to compete, not to engage? That's what I think the member is saying, which makes sense. I mean, you don't need to disclose because disclosure means an offense. So what you do is not to engage. You get the point? Look at it for me, since we will, but it sounds pretty straightforward to me.
In other words, you want to know, Chair, where do you really want to place the emphasis? On the part of the disclosure or the non-engagement? Because in my view, what you want to do, since you would have had internal knowledge of policies, what you're seeking to do is to prevent the person for a defined period not to engage anywhere else. But the disclosure, what does the disclosure do?
Remember, the disclosure covers something. The disclosure is broader than B. B is really dealing with engaging in some occupational activity. A, however, is going beyond just occupational activity. It says whether gainful or not. So it could be so you could be joining a body or a committee or some group that the tobacco industry is also connected with. So it's really a question of whether we want to
well, you need to be clear.
I just wanted to add, because I'm following the discussion. For A, we're really, for A, I think we're really looking at disclosure, and on that front, disclosure would empower the authorities to know whether a person should be engaging or not be engaging. And again, it could go beyond whether the activity has some gainful resources, so somebody's getting some economic benefit or not. So I think A is much wider in terms of how it is structured, and it would encapsulate a lot more than just engagement for economic activity. That's how I'm looking at it.
So that would therefore, Mr. Edwards, if I may, thank you, member, be Mr. Edwards. If what you are intending on saying is that even if the activity that you engage in is not a promotion of the industry, you are required to disclose within that time period. In other words, you know, you join a society of smokers, I don't know, I'm just saying, right? Then you would need to disclose so that your direct involvement, even if not to promote, but just to be a part of a fraternity, is necessary to track your level of engagement. Then maybe you need to be clearer in articulating that position. You understand what I'm saying? Otherwise, you run the risk of the law being there's a confusion between disclosure and restrictions, right? And engagement.
But Chair, the A and B are. Let me explain, if I may. A is dealing with your engagement even after the 3 years, you know. It's not dealing with, so yes, so I appreciate Member Wilson's intervention. A is dealing with, for example, this is 2023. You are saying that you are considering getting into some activity with the tobacco industry in 2027. That's what A is dealing with. B is dealing with your getting involved in an activity between 2023 and 2026. A is covering a much broader scope. A is not limited to the 3 years immediately after your employment.
The point I'm making, can you make it clearer? Is that possible to look at how you word it the next time around? Maybe look at rewording it to make it clearer. Is that possible? Could you look at it?
I can look at it, Chair, but
You think it's clear enough?
I don't think we were reading it correctly, to be honest. I don't think members...
Yeah, but you know, in fairness
so
to
maybe it needs to be
in fairness
reworded.
to the combined capacities in this room, the fact that other lawyers and other lay people like myself may have had that interpretation is a part of our learning experience. So we try to refine,
it,
right?
I appreciate it.
So what I would recommend is that you attempt to see how you can clear it up so that the meanings are a lot more transparent.
It is strange that the explanation now brought more clarity.
Yeah, but we don't have time to do that kind of explanation in every circumstance, and this is why we're here. So look at it, Mr. Edwards, and just make a thing there. All right, so
sorry, Chairman, just if I may, a tidying up note, just the opening words, a person who, as a public official, has or had a role in the development. I think this is now a specified public official. Remember, we have now defined specified public official. So if you look back at, to me, when you look at the definition of specified of public official, I think it captures that person.
So you're assisting with the clarity of wording?
Well, perhaps, maybe not. I don't know.
No, it's fine. I think that's what you're doing. So Mr. Edwards will bear that in mind and his team. What were you saying?
I'm saying, Chair, I don't know if that's the policy. I think it's probably the intention to make it wider, not just to apply to the specified public official who is actually performing those functions in a specified public body, but that's for the instructing ministry to look at and determine.
Again, it sounds that more justification for the clarity. So Mr. Edwards, just make a note of that and take that on for me. So that would members complete to the extent that we are complete. Clause 9 and with two sub-clauses to return to. And then we go on now to clause 10, Mr. Edwards. And no, sorry, we just did clause 10, which requires some simpler language, if you will. Oh, Member Dennis, right? Denise.
No.
Cheryl.
Right. No, member.
Hi.
Just, hi.
I didn't know you were online.
Hi.
Sorry, that's the Pan American Health Organization's legal counsel. Go ahead. What's your input?
Thank you, Minister. And just for clarity, I'm consultant in health law and regulations at PAHO. Just want to mention earlier, just to go back a little bit, I recall that Ms. Birch had read and had shared some provisions from Guyana's legislation, and you also had asked whether there were other provisions in the region. As the representatives meet and consider, I'd like to offer or suggest a consideration of Uganda's legislation, which seems to be clear and seems to offer clear language in respect of how public officials are treated specifically with respect to the provisions that we are now looking at, clauses 8 and 9 and so on. Outside of Uganda, I want to also highlight Antigua and Barbuda, which has a 2018 Tobacco Control Act. Now, that act is not yet in effect because they're currently working on their regulations. However, the act, has been signed off and all of that, and it is made public, and regard may be had to that as the deliberations and considerations continue as it relates to finalizing these provisions that we are looking at.
Thank you very much, Ms. Dennis. So you're adding another jurisdiction to
Antigua and Barbuda, Uganda, there are others.
No, to Guyana, because we're looking at
Guyana,
regional.
right. Okay,
so the team is so advised, and hopefully they can do some more work to come back to us on that. All right, Mr. Edwards, can we go to, first, let me just pause for a few seconds to recognize some primary school students and their teachers, administrators, guardians from Banbrook. Is it Banbrook or Boundbrook? Boundbrook Primary from Port Antonio. Thank you very much. Happy to have you. And we hope a number of you one day will be in this chamber providing guidance for the rest of us. By then we'll be geriatric, right? All right, so Mr. Edwards, you want to take us now to 11. No amendment was recommended. Is that accepted by all? If that is the case, we go to 12. The prohibition of smoking in enclosed public space. Huh? We're deleting, right. Are we agreed that we're deleting 12?
No, the decision, Chair, was that no further amendment was needed. Not that we're deleting 12.
It's deleted here. What was the amendment?
It's deleted there because it was provided as if amendment had been needed. So that's why we just struck it out and said we don't need any amendment to 12.
Well, we need a key for this document, because I wouldn't know that a strikeout means leave it as is. Oh. Normally it means delete.
We have a little note above it saying yes.
But all right, I mean, if there is no comment on that, then we move on. I don't see anybody wanting to comment. SG, you have any comments? I have to consult with you on every clause, just to be clear. All right, so can we move to 13 then? Mr. Edwards? Display of no smoking signs. Was there anything there? Committee agreed that the provision be amended to allow communication of smoke-free or no smoking areas to be included for persons of varied physical abilities. Is that accepted by all? Yes?
Sure.
Yes.
Very early in the deliberations on this bill, there was a concern that I had brought out that there were in this document, the bill, two different sizes in terms of signs. I can't recall exactly where it was now. I think it's somewhere in the schedule, but that there needs to be consistency in
can you elaborate
sizes of the signs.
This is on the which signs?
The signs that are
the no smoking signs.
No smoking signs.
Okay.
I just want to make sure that we are consistent in it. But as I say, I can't recall exactly where it is now. But if we can be guided by the committee and assure that it is consistent, then we can move.
That subclause 2 speaks to 216 mm times 279 mm.
Yes.
Mr. Edwards, is there any ambiguity there, or anyone else? Can you turn on your mic, and could you turn yours off, please? Your mic is on. Yes, thank you.
Yeah, I recall, Chair, the concern about the size of the health warning, the graphic health warning. I'm not recalling the inconsistency in terms of the no smoking signs. I was aware that there was an inconsistency in relation to the graphic health warning size of the graphic health warning on packets, but I wasn't aware of.
I remember having that discussion. Remember, that's why I was asking whether you were speaking to the packaging or just the signs that you put up.
To be fair, Chair, I cannot exactly remember. The size hit me just a while ago, so I was wondering if it was.
Okay. I see Senator Longmore. You're recognized. Go ahead.
Thank you, Chair. Sorry to go back, but I just had a chance to look properly. What is the final decision regarding Clause 12? Because I see where the lines go through it in the document. So is it that this is, what was the final decision, please?
It's to be as is. So it's still there. It's to be read as is.
So can I get a clarity as to what it will read then?
Exactly what's there except the lines.
So no person shall smoke a tobacco product or relevant product or electronic non-nicotine decorators in or within a 5-meter radius of the entrance, exit, window, etc. That is how it would read.
Right. That's what is being proposed.
Is this consistent with the distance that there was an inconsistency with the distance that was recommended here with another part of the legislation? Are we going across the board with 5 meters?
My interpretation of what the clause says. Mr. Edwards, you want to?
Well, we have distances for different purposes, as members will recall. I mean, we have a distance, as Senator Longmore is speaking of now, in relation to the distance from an intake, but we also have the distances in relation to distance from certain facilities, you know, like schools and so on. So there are different purposes for different distances. So we need some clarification on what the concern would be, because distance is going to be different depending on the circumstance.
Okay. All right. Well, I'm not in chamber, Chair, so I will look at it properly, because it seems like we will be meeting again. And if I need to seek what is the justification for those different distances, because my concern is that the smoke doesn't recognize distance. We are the ones recognizing it, so we need to protect it as would be necessary for the best protection. Thank you.
Thank you very much. All right. So Is there any further clarity that is required on the point raised by Member Guy, Mr. Edwards, or Member Guy? Are you comfortable until you recall fully what your concern was? You seem to be unclear.
I think I found it. That one is good. The challenge I have was actually in 13.4.
Can you raise it when we get there? So. Are we okay, Mr. Edwards, or others, with Clause 12?
Language change, Chair, is in relation to subsection 2 that speaks of allowing for communication to persons of varied physical or developmental abilities.
Is there any comments on that or any concerns?
Sorry, Chair. I'm just looking at the bill itself, not the draft amendments.
Right.
And in 12.4b, there are actually some square brackets. Not sure why those are in the bill, but the committee would just need to. Normally, square brackets indicate that it is up for discussion and a decision needs to be taken. It's on page 18 of the bill. So I just think a decision needs to be taken whether or not the words should remain or they should be removed.
Got you. Mr. Edwards, you noting that?
Chair, that will definitely be an error, because we wouldn't have bills printed for Parliament with square brackets. So those square brackets would not have been introduced through the committee process. That would have been a typographical error. So the ministry would not have sent the bill forward for tabling with brackets in it like that.
Okay, but nevertheless.
So we don't have any issue with what is in the brackets.
Yeah, worthwhile observation, and so just take note of that. We don't need to detain ourselves on it beyond recognition of it and the correction. All right. So that would be. Can we then move to Clause 13? Mr. Edwards. So this deals with display of no smoking signs. Member Guy had a point. the committee agreed that the provisions be amended to allow communication of smoke-free or no smoking areas to be included for persons of varied physical abilities. Member Guy, you want to just take us through your concern, please?
No, the concern I have, Chair, is, okay, 13.2. The size of each no smoking stand shall be at least 216 millimeters by 279. That is 8 by 10 in terms of inches, which is the standard for the letter size paper we have here. My concern was in subsection 4, that in case of a public conveyance, the owner operator of a public conveyance shall ensure that at least one no smoking sign is prominently displayed in each compartment of a public conveyance and shall be at least...
You're reading from the bill?
Yes.
All right.
76 by 229 millimeter in size. My thinking was that was a bit too small, because that is translated to 3 inches by 9 inches. Now, how prominent is that for people to see it? And that's my concern. It should be bigger than that.
Well, since you wear glasses, it may need to be bigger. And I. No, the point I was making, I'll be a little facetious, but the point I'm making is that is there a standard size that represents appropriate visibility within a particular distance, irrespective of the fact that you have 20/20 vision or you're aided in your vision? It's a kind of difficult point to. I guess you can be guided, right? So what's your take on that, Madam SG? Yes.
I'm just suggesting that maybe we should just look to see what the convention says and what the guidelines.
Great idea.
And follow
I agree.
that.
I agree. So can we do that then and see what? And note, we're citing precedent here, despite the uniqueness of our legislation. SG has said we should look at what the convention is. We may have to do that in several other areas, SG, just to make the point. All right, so let's make a note of that and then just conform to that. I don't think that we need to reinvent the wheel, if you will. Is that okay with you, Member Guy? Yeah, okay. Is there anything else on clause 13? Mr. Edwards?
So I had read subsection 2, Chair, referring to a manner that allows for communication to persons of varied physical or developmental abilities.
What's your comment on that?
My colleague is indicating that we could also make reference to the Disabilities Act if the members wish. So when we speak of varied physical or developmental abilities, we could speak of a loss for communication to persons.
It's persons with disabilities.
That's with disabilities.
The defined term in the disability. And you could say as defined in the disability.
Under Section 2 of the Disabilities Act.
Yeah, that should be acceptable. I don't think there's any controversy here. Anybody? Any comments on that, or we can accept that? I don't see any.
So the language would then read, Chair, after the word persons, we would say with disabilities as defined under Section 2 of the Disabilities Act.
Okay. Are we all agreed on that?
Here is that, Mr. Edwards. Can you...
In the proposed subsection 2, the last 2 lines, where we have allows for communication to persons, instead of the words of varied physical, we would say with disabilities, comma, as defined under Section 2 of the Disabilities Act.
Okay, that's important. The fact that we wear glasses, we're all part of the disabilities community, right? From a visual perspective. All right, Mr. Edwards, can we move on then to...
Thank you.
Chair, may I just make a comment about the criminalizing of 4?
Of?
I'm just
subsection
4. So okay, fine. So my sign wasn't specifically 76 by 229. Are you gonna charge me for that, for heaven's sake? I'm just saying that I don't know. I think the offense should be at 1, not having the sign. But I would advocate for a different kind of penalty if the sign doesn't comply.
Let me just say that, if I may, that while I appreciate the point on the issue of the extent of the penalty juxtaposed against the offense, where the offense is a deliberate attempt at concealing the warning. Yes, and we can't be naive, and I'm not suggesting you are, by the way, respectfully. We also have to recognize that there are going to be, particularly in this industry, tricks and trade around trade, sale, and consumption. And we were part of a series of presentations in the early stages of this process where we identified very tangible examples of the approach to pursuing this particular product, incentivizing consumption, and if you, for want of a better terminology. And the issues around signage is very important. It is as important as saying you shouldn't entertain underage persons in alcohol establishment. I mean, because it creates an issue, and I would not eliminate the temptation, to put it diplomatically, of putting up a sign that is up, but you can't read it beyond, especially if you wear glasses like myself and member guy. So I would be a little concerned about that, if you understand what I'm saying.
Yes, sir. I'm not saying that there ought not to be a penalty. I'm saying, should it be a criminal penalty? If the signs are there, but the sign did not comply with the size that is specified.
Maybe we can cite some precedent on that also. I have to lean on what exists elsewhere in this regard. But again, I say a penalty that can be paid while achieving the objective of a sign that you can't read may be well worth it in this instance. And that would concern me. So let's see what exists elsewhere and maybe come back to that. Mr. Edwards, you want to go ahead?
Chair, we're just saying that this is one of the provisions where there isn't a fixed penalty option. So maybe the ministry is okay with introducing a fixed penalty option for this section. There isn't currently one in the bill. So if it may be the kind of activity that should attract be ticketable rather than having to go to court.
Again, I think we should be guided by the precedent out there, and there are many laws in Jamaica where the fixed penalty is so ludicrously low that there's greater incentive to breach and pay than to avoid, and that would be a concern to me in this case. I see, Madam SG, you had your hand up. Your mic is on. All right. So can we look at that then and get back to come back to this particular point? We're moving the needle very slowly, but we're very deliberate to try and do it right. So I'm not discouraging those alternative views. Mr. Edwards, you want to go to
We didn't have any further changes before 19, as I recall.
But let me just take it one at a time. So which point? The one we just completed?
15 in my notes.
Right, you have points. I have 2.
Oh, okay.
So you have no amendment was recommended to 14. Can we agree to that? We don't want to come back here to these areas, so I want to make sure I put it on record. So no amendment was recommended for 14. If that is the case, then we move on to 15, protection of children. If the definition of relevant product in Clause 2 were to be accepted, Clause 15.2 will need to be deleted with consequential amendments being made to Clause 14.4 and 14.5. Mr. Edwards, you don't have that?
I have it, Chair, but we don't have it on the sheet.
Let me just finish. And then further, the technical team is to review the Child Care and Protection Act regarding the recommendation of the Ministry of Education and Youth on indirect and direct access to smoking apparatus and other recommendations in relation to children from the Ministry of Education and Youth. It was agreed that a strong penalty should be attached to the sale of tobacco and relevant products to children. And I am in full agreement with that. And I cited, I recall, an example of a particular school in Kingston where a big sign was across the road selling vaping material literally across the road. And I have a major problem with it. Yes, from the school. So, Mr. Edwards, I'm surprised you have missed that. What, you have a comment on it, or do we need to return to it?
Penalty was already strong, Chair, in 15.2.
Huh? All right. Remind us of it, please.
All right. So if we... I'm just going through the bill. 15.3. Yes.
If you have... well, Mr. Edwards, look, you can probably help us, Ms. Birch or anybody else, if you have it before you.
15.4, so I'm just having a little difficulty maneuvering. Sorry, Chair. The 15.4, a person or a seller who contravenes subsection 1, 2, or 3, and this is supplying tobacco products or electronic non-nicotine products to a child, subject to the amendment agreed in relation to relevant product, that person would be liable to a $1 million fine based on 15.4. Or to the penalty specified in the 5th schedule. So those are the current penalties proposed in the bill, Chair.
What was the concern, SG? You had a concern on 15 beyond what is there?
The Joint Select Committee on August 30, 2022 took a decision to delete 15.2 to renumber the following provisions and do some numbering changes, like for instance in the renumbered 15.4, which would be now 15.3, it would now say 1 or 2, not 1, 2, or 3. And in the renumbered 5, now 4, it said not, there was, the S's were taken off, the pluralization of the word provisions and subsections were removed. So those are the changes I have. Because there was a deletion of 15.2, there had to be some renumbering to the provision. That's a decision I have of August 30, 2022. So you could look in the minutes and find it.
Right. Can we do that? And is that Mr. Edwards?
We have that, Chair. We just haven't included it in the list.
All right,
here.
make a note and make sure it's included next time, so we read it in the records. Okay?
Can I just ask the change to the penalty? You said in the bill, but the fixed penalty is much lower. I'm looking in the bill and I see for 15.4 a $100,000 penalty as a fixed penalty.
I think...
So the fixed penalty means you could discharge your obligation by just going to the tax office.
That's the point, yeah.
So is that really the policy for 15.4, especially if you're talking about protecting children?
I am with you on that.
Should you really have it as a fixed penalty? Because you can remove the fixed penalty and just leave it to going before a court.
No, I am with you on that. I think where this breach occurs, Mr. Edwards and colleagues, it should be exposed in the first instance, because there's an incentive not to do through exposure and fear of exposure. And secondly, the culprit should be charged and required to pay where the offender. So I'm inclined to agree with that position. Yes.
May I just say, Chair, normally the fixed penalty is usually lower because it's an incentive for you to pay and not basically take the matter to court. So my suggestion may be that this should not be a fixed penalty.
Which I think is a point that the SG was making, which I'm inclined to agree with. Mr. Edwards, are you're getting what has been said and why?
So, Chair, I heard the point about the fixed penalty being an incentive and therefore being...
No, yeah, what was being said was that the fixed penalty normally is to incentivize payment as opposed to the court. In this case, given the nature of the breach, meaning imposing smoking habits on children who we are sworn to protect, we probably should provide greater negative incentive against that action, which means court and a determination and a penalty. Okay?
And therefore remove the fixed penalty option.
Right, exactly. Okay. So remove that and then come back to us with a wording that reflects that. Okay. And I'm very much supportive of that.
Chair?
Yes.
And I noted in your comments about 15, there were comments from the Ministry of Education and Youth. I was just wondering if there has been some sort of reconciliation, if you may want to call it that, between the provision here, protecting children, and Section 40 of the Child Care and Protection Act. One reason I'm raising that is, for instance, although it seems as if the committee has now taken a decision to remove the fixed penalty, because that would have been some dissonance with what is in the Child Care and Protection Act and this law. I'm just wondering if they're both aligned, or if, for instance, Ministry of Health is perhaps talking to the Ministry of Education and Youth about making changes to their act based on the requirements of the international obligations.
Well, we do talk. I don't know about this particular issue, Ms. Birch, if a conversation has been had with the Ministry of Education around the alignment. But I will say before you come in that given the time period and the era that this particular bill is being promulgated, we may need to modernize given the various challenges involved in tobacco consumption, which involves new devices like the vaping and so on, and greater accessibility, greater capacity to conceal, etc., etc. So I do believe that we should see this as an opportunity to modernize and become more relevant to the context. But back to the question, is a conversation taking place with the ministry?
We have not had those conversations, Minister, so we would have to have those conversations with Ministry of Education.
Can I recommend then that in the rewording, a discussion be had, and that there is no conflict between the two pieces of legislation, while recognizing the need to ensure that this piece of legislation ultimately becomes a more modern, contextual, applicable piece of legislation. Is that okay? All right, thank you. Any other comments on this? If not...
Chair, just something minor. Could we change for consistency? We have been using millimeters in terms of sign. This says 12 by 8 inches. Could we do the metric?
12 by?
8 in size, inches.
Oh, that's a sign. You back at the sign.
No, I'm just saying I don't have a problem with the size, but we have been using metric.
Oh, okay, metric.
In the other
Okay.
millimeters.
All right, make a note of that for me, please. Okay. All right, so if that takes care of 15, we still have to return to adjust wording, etc. 16 to 18, I see no amendments were recommended for the clauses. And if that holds true, I would move on. If there are no comments, none? Okay. Then we go to clause 19, which is where Mr. Edwards had gone to prior to us discussing 15. Mr. Edwards, you want to take us through that?
Yes, Chair. This was the issue which had created some concern about the breadth of places where the sale of tobacco products or relevant products will be prohibited, and because the reference was there to public places inadvertently, so therefore the committee agreed that the paragraph referring to public places should be deleted, and that is what is being done in 19. So 19 will only refer to A, facilities where healthcare services are provided, B, sports, athletic, or other similar facilities for use by the public, C, educational facilities, etc. It will not include public places.
I'm curious, what is the kind of benchmark standard for this? Can we get some information on that next time around also? I'm sorry, I'm referencing a lot of these adjustments.
Just for curiosity, if we're leaving out any important areas.
Yes, exactly. Can we see exactly what this definition of public places refer to? Just make a note of that for me, and then we come back to this. I mean, I don't have a problem with being more specific, but I don't want to create any loopholes for what we're trying to achieve.
Yes.
Is that okay?
Yes, Chair. Yeah. It is defined earlier, the term public place, but you mean in the context of restriction of sale? Okay.
What I've done, is that we would have deleted public places, but then we would have been specific in identifying those areas.
The prohibited areas, yes.
And so the concern I believe the chairman has raised is whether or not there may be others that we could identify to be included in this list.
Or there is a all-encompassing clause that captures a principle that would discourage or eliminate cross-contamination, meaning those who choose not to, being contaminated by those who are, children exposure, that kind of thing.
Okay.
If there's somewhere there that captures that, then each circumstance could be contextualized and an assessment made. If you understand what I'm saying.
I do, Chair.
And maybe we could link that to things like permits or whatever, specific permission.
Well, we have a provision, paragraph F, which could allow for the minister to so prescribe, Chair. Paragraph F is a sort of saying such other places as may be prescribed by order. So that order could create that permit regime.
And we could activate that as we see a breach.
Yes.
All right. Or an injury. Committee members, are we accepting that flexibility exists? Yeah. Okay. All right. So I would still want to see what other, if could be specified, but then once we include that, then it gives us the range and the reach. All right, clause 20, information requires on packages, etc. The size of the area for graphic health warning should be 80 per centum wherever in the bill it is provided for. Mr. Edwards, you want to take us through that quickly?
I'm sorry, Chair. I just have I'm not sure if this is something which is already noted, so it need not be brought up again, but the terminology, tobacco or nicotine products and electronic nicotine delivery systems, I have a note that all of that is to be amended and relevant products substituted, having regard to
where are you?
In 20.
20.
Yes. But it appears in 1, 2, 3, and 4. The phrases. that are to be removed and relevant products substituted.
Okay, I don't see it here in the summary. Huh? I'm being shown that in the definition of relevant products, a nicotine product, nicotine device, or any electronic non-nicotine device, this amendment will incorporate ends as relevant products throughout the bill. Yeah. So that's a decision. Say Edwards, go ahead.
Okay. So in relation to subsection 3, the adjustment was made to change the percentage to 80 for consistency. So subsection 3 reads, the size of the area of the graphic health warning mentioned in subsection 2 shall be at least 80% of each principal display surface of the package of each tobacco product or relevant product.
Okay, is there any comments from members? Members are agreed on this. That's clause 20, agreeing to the 80. Yeah? I don't see any objection, so let's proceed.
There was a question that was asked some time ago and some answers were given. What is the, we have been using our regional bodies as a sort of sounding board. What is it like in other Guyana, St. Kitts and Nevis? Mention was made of Uganda in terms of, and Kenya. What is the size there? Just asking. Yeah.
I don't have a problem with exploring it, but in this instance, the bigger the better, as far as I am concerned. I don't think that there's probably more to be gained from our objectives to discourage through graphic warnings than from observing a standard size, unless we are lower than the standard. And I think 80 is probably the higher end. The next best thing would be to have a totally blank package, so there's nothing at all on it, including the actual marketed brand, which exists in some jurisdictions. So I doubt you'll find more than the 80. You may find less, but I'll be comfortable with the 80. So, Miss Wright, yes, Cheryl Wright, go ahead.
Yes, thank you, Chair. So the FCTC, we're reminded that the FCTC really represents the floor and not a ceiling. And although the CARICOM regional body for standards and quality, CROSSQ, although there was some regional standard, and I think that regional standard was at 50 or so on some time ago, or several years ago, the trend is actually to move upwards because of the evidence, again, based on the fact that the FCTC is really evidence-based. And we have seen a move in the region to greater. I think I am looking currently at the Uganda legislation. I believe it is about 80 or 85. I stand corrected because I'm still going through while trying to catch up and follow up with the deliberations. In the region, we have the evidence of Uruguay, that's in the region of the Americas, being 80, and several others trending up. And as you know, moving toward clean packaging, which we're not, or which a bill doesn't propose. But again, 80 is really evidence-based, based on the fact that the FCTC represents the floor and not the ceiling in terms of where we can go.
Okay. All right. So I'm comfortable with where it's at, and I'd recommend that we stay there. With unless members have a major opposition, we can listen. Otherwise, can we proceed? Mr. Edwards, you were commenting on this or no?
No further comment at this point, Chair, on this one.
All right. So let's move to 21 to 23. I see that this says no amendments were recommended for these clauses. Any comments further on that? I don't see any hand up. or anyone commenting? That's 21 to 23. So if there's none, then we go to 24, ban on tobacco advertising and promotion. All right, so the committee agreed to change the order of the words in subclause 1 along the line of all advertising, promotion, and sponsorship of the tobacco products or relevant products are prohibited. It was agreed that "and" should be added to the clause. It was recommended that subclause 5 be amended to avoid any loopholes or abuse of the use of the term purely incidental. One member stated that the proposed provision at the subclause 5A seems like a provision for subsidiary legislation. The committee is to decide on whether to accept the proposed amendment, and the committee agreed with the proposed wording of this proviso at end of subclause 5. Mr. Edwards, you want to add anything to that? Issue of advertising is a very standard feature of tobacco legislation. Very standard. I mean, it really shouldn't be controversial. It's really how you prevent it than to allow any aspect of it. So I really hope that we can agree on that. I don't even have to ask for examples, to be totally frank. I've seen too many. But Mr. Edwards, you comment, and then I see the SG wanting to comment. You have any further to add, or SG?
Chair, as the committee, as you and your committee had charged the technical team to meet, we did meet in March, the latter part of March, and the issue of advertising is one that did bring about some amount of discussion and raise a number of issues. The Ministry of Health considered a number of cases the AG's chambers had shared with us and other research that we had done. And notwithstanding that there are jurisdictions where there have been provisions that cover prohibition or bans on advertising that have been struck down. Most of the cases and most of the research that we are aware of that's relevant, that we consider relevant, notes a difference between the protection of freedom. Now we're going to constitutional issues, the protection of freedom of expression, different from freedom of commercial expression. So the question is whether the guarantee of freedom of expression is going to be different when you're dealing with advertising or commercial expression or commercial communication.
Sorry, why are we going there though? I mean,
we're going there, Chair, because this was a significant matter of discussion between ourselves and the legal departments, and although the Ministry of Health...
Yeah, but this is a matter that there is sufficient precedents established where court cases have been decided on around some of these issues. I know and expect perhaps that there's likely to be legal challenges around elements of this legislation, because it happens very often all over the world. And it's almost a default strategy of the tobacco industry. I stand to be corrected, but I rarely ever see a successful challenge when they are mounted based on the scientific evidence around the impact of tobacco consumption. Again, stand to be corrected, but that's my view. In any event, I believe that as legislators, we need to send the strongest possible signal from a public health standpoint as to what the impact of this product is. So you know, there are many ways in which there are attempts at promoting a brand without quote-unquote advertising. I think we have to be very careful that we try to avoid that. And so I'm prepared to be rigid, but let me hear the SG, because I'm sure she has a comment on this particular issue.
Yes, Chair, and I actually raised the comments with the ministry at the meeting, and we shared the we shared our concern, we shared relevant case law, and we also shared what we thought were ways to address the concern. So we didn't just point out the concern, but we said that these are ways you can fix it. So I'll go to Canada, and the reason we're using Canada is because the constitutional test that has been approved in our courts all the way up to the Privy Council is a Canadian test, R.V. Oakes. It's a 1984 case. And that test was applied in a case that was carried to the Supreme Court in Canada, R.J.R. MacDonald, Inc. And in that case, the challenge was to a complete ban on advertising tobacco products. And the Supreme Court ruled that the complete prohibition was incompatible with the Canadian Charter, and they used the test that we use in coming to that conclusion. However, they also looked at the international obligations, but what's important in those international obligations is that it allows countries who have a constitutional issue to do something a little less. So rather than the complete prohibition, it allows countries to opt to do restrictions. So it's not that you don't have any kind of restriction at all, but it gives you guidance as to those restrictions. So after that case, Canada amended their law because the complete prohibition was struck down. And what they now have, and what we shared with the ministry, are restrictions on advertising. And they are pretty prohibitive, so to speak, but they're not a complete ban. And so it does send the message about how seriously you treat with the issue. It also is compliant with your international obligations, but from my perspective, what's more important is that it is consistent with our constitutional right to freedom of expression.
Right. So I'd want to see what that alternative is from the complete ban, maybe to look at it. But Mr. Edwards or Kadian, you want to comment on that? Or maybe Miss Cheryl Dennis Wright, just what is your difference with what is said by the SG versus what we are recommending?
If I may begin before my colleagues continue, I think we look at the difference where we're left off, the issue of whether freedom of expression in relation to advertising is treated in the same way as freedom of expression in any other regard. Because the question of advertising as a form of expression is seen as a form of commercial expression, which the courts also consider to be distinct, or that can be distinguished from expression in the broadest sense of freedom to communicate ideas, etc. So we in the ministry were leaning to the view that commercial expression and the broader concept of freedom of expression are to be treated differently. And therefore that the protections that one would have in relation to the broader concept of expression of ideas, etc., would not apply in the same way in relation to advertising or promoting commercial information. And that's why we did not we did not hold that a ban on advertising should be treated in the same way as overturning one's right to freedom of expression.
Can you cite any other case law beyond what has been cited by SG to support your position?
Ms. Birch will give some.
I can't hear though. Ms. Dennis, what about you? Your hand is up. Go ahead, and then Ms. Birch, we can come back to you. Ms.
Yes, Minister, thank you. So we have several other examples. For instance, Uganda, there was a challenge in that jurisdiction. There was a challenge in relation to their bill, and also in relation to this provision. And, you know, it withstood the test, you know, it was not overturned. So I would also invite the committee to really look at that. We also have other examples. I am trying to pull up some here. We know that in Colombia, for instance, and I'm mindful, I'm certainly mindful of our constitutional safeguards, but I also want to point out other, you know, legislation or other countries in which we may have had other challenges or similar challenges, such as Colombia, Uruguay, Panama, and so that we can draw from those examples. But certainly, we want to look at Uruguay based on also their constitutional model. And as I said, we are very mindful of our situation. But these offer strong positions for, that we want to refer to. And I want to sanction that which Mr. Edwards has mentioned in relation to how we treat a complete ban on taps, that's tobacco advertising, promotion, and sponsorship, as opposed to, other commercial expressions or freedom as it relates to commercial or other forms of commercial expressions.
Chair, if I may continue. One of the observations that we noted in relation to the McDonald case was that it fell down on evidence. The issue, one of the challenges was that in making the case for a ban, the court had not considered that there was strong enough evidence given in relation to the public health consequences of tobacco smoking. Now, we are saying that there is no sufficient evidence that we can bring in terms of the public health consequences of smoking if you're looking at a proportionality and balancing to determine whether a ban is to be treated as adequate as opposed to being excessive. We believe that there is sufficient evidence of the public health negative consequences of smoking.
Sorry. Chair, if I could just respond to that. I wouldn't put it quite the way Mr. Edwards put it. The court was actually looking at one aspect of the test, which is a minimal impairment aspect. And when you look at the minimal impairment, meaning how far do you go to, because you're balancing rights, that's what you're doing. And how far do you go to in infringing a right when balancing other rights? And the minimal impairment says, can you do it in such a way that you don't go very far into infringing the right? And what the Canadian court found was that you could protect the public health of persons and protect their right, but still not go so far to infringe the right by a complete prohibition. The fallback was the minimal impairment test was satisfied with the restrictions instead of having to go as far as the complete ban. So it's not that it's not so much that there wasn't enough evidence to prove. The issue is really, how did the minimal impairment test, how was it weighed by the court? And the court thought that there was an option, and that option was viable, and also that option was also recognized in the convention.
Are there any other cases outside of the Canadian case that proves that where that ruling was consistent?
I received, and I'm very grateful to the Ministry of Health and Wellness and Mr. Edwards for sharing some of the cases which we plowed through, including the Colombian. The reason I am not relying on those is because their test is not the same as ours. Our test is identical to the Canadian test. So I cannot see how I could be persuaded to use another regime where the constitutional scheme and the constitutional test is not identical to ours.
Okay. the issue, therefore, is one that is balancing science, where Mr. Edwards is suggesting that we have more evidence to support the negative impact of tobacco consumption, and therefore can argue a case in protection of society in its collective form against a constitutional framework, according to SG, that would see an extreme position being counter to that balancing of rights constitutionally. The question for me is whether there is any absolutes in terms of exposure of the branded product, because while you may restrict and limit almost totally in the strict definition of advertising and promotion, the visibility of the product is almost guaranteed by nature of the fact that it has to be available somewhere and people will see it. So I don't know if you can argue balance in an absolute way to suggest that somehow the product is not, you're depriving people of the right to access or even to be exposed, when if you go into the typical convenience store, the product is right behind the cashier and available to whomever enters, overage, underage, everybody. I mean, who has access or entitlement depending on the other rules that apply. So again, I think there's a nuanced position as it relates to whether a fundamental right is breached. But I do take the point that we need to find that legislative compatibility between our jurisdiction and others. And I would ask that the team perhaps looks through. I heard Ms. Dennis speak about the Uruguay, is it Uruguay, I think she said, model. Uganda, no, not Uganda, because I think Ms. SG has already established that there are differences between Jamaica and Uganda. Huh? Uruguay, I think it was Uruguay and Colombia. Yes.
Sorry, Minister, I did mention that there are cases in Uruguay, but
Uruguay,
Uganda
that's what
as
I
well.
call.
Uganda as well had a similar case, and I am of the view that they may have a similar model to ours. So
Well,
I would encourage.
I want to be sure of that, because this is something I am prepared to suggest, recommend. Clearly, this has to go to a bigger chamber. That if it has to be tested, we test it. I mean, I'm of that view because I think it's sufficiently important.
So,
But
Chair,
I'd like
just to
us
clarify, though, we're not talking about a model, you know, we're talking about a constitutional
Yes, I know.
test.
I'm aware.
Right, a model is something different than what I'm talking
Yeah,
about.
no. Well,
Okay.
that's why I'd ask. That's why I'd ask Ms. Dennis, since he cited the many different jurisdictions, which would have been similar to the Canadian constitutional framework. So I'm going to ask that we perhaps dig a little deeper on this. I do maintain the point, though, that fundamentally, the rights are not absolutely breached because the product has to be somewhere and is exposed and is available through exposure in a distribution trade. I think so. What I want to discourage is the branding being exposed in a way that creates sufficient attention to incentivize purchase. But for information purposes, I understand that people have a right to know. But I do believe that in a natural course of commerce, certainly through the distributive trade that is allowed, that right to know is almost equal to the right to access. I mean, I could be wrong, but that's my personal view. So can you use the next session, along with all the other list of things that you have to do, to give us some further clarity on that, in anticipation that this could be a controversial issue, and then we make a decision based on that. Thank you very much. Is that the only, that's the only comment on that particular clause? I want to close for the day and go to the rest of the agenda items. Is that okay? Any other comment on this particular clause? I mean, we're going to come back to it, obviously. All right. So if that is the case, any other business would be item 8 before we decide on the next meeting. I don't know if this is where I raised this, but I want to raise an issue here. With a letter was sent to me through the Houses of Parliament recently. Sorry? To all members, just to be absolutely clear. All members of the House of Parliament, through the House of Parliament. Invitation of application to Careers Limited Tertiary Scholarship Program 2023-2024. And of course, a communique to dear Member of Parliament, and it goes on. And you know, it perked my interest and maybe raised some concerns that this would have been not the right to an entity to promote its offering, even though that is now under active consideration, but that the Parliament would be the purveyors of this kind of narrative. I kind of have a problem with it, I mean, I must say. And it's something that, from the public health standpoint, we'll probably raise with the Parliament. I mean, this is an active discussion taking place, and I don't think we should be encouraging the promotion of the brand through this way or others.
In my mind, Chair,
all I'm saying is I think it's something we need to consider, and I wanted to raise it.
No,
because
you're quite right, Chair.
It's quite relevant given the discussions that are taking place, not to cause any disquiet among members of the House of Parliament and the administration and management. I'm just saying, from a public health perspective, it sends a wrong signal, put it that way. Yes, you're saying...
Chair, that so the scope of an objective of this legislation that we are pursuing is against any such activity, right? And this might be, in my mind, a subtle way of inviting us to participate in any such activity. And I would want us to be very cautious in participating in any such activity when we know that as a parliament we're pursuing a type of legislation that is against that. It might be a temptation in my mind.
And I say, I'm not kind of being critical of the particular entity or subunit within Parliament. I'm raising it because it could be done, I'm sure it was done without any sort of malintent, but I'm saying it's worth raising it at this level given all else that is happening and the signals that we want to send. All right, in terms of any other business, is there any other comment? No? I see none. In terms of the next meeting, date of the next meeting, July 20th for the next meeting. Okay, so are we all okay with July 20th? I think it was circulated. And what time, just to be clear? 10? 10 a.m., not 9, 10 a.m. Okay. So if I were coming to the July 20th meeting, I would be on time this morning. All right. Having said that, thank you very much. I think we made some progress, but there are a couple of things that we need to clarify and deliberate on. So Mr. Edwards and team, thank you. And SG, thank you very much. Colleagues online and in the house, thank you. Until the 20th. Meeting